by the European Union and its member states. We regret also the fact that this resolution seems to establish a hierarchy amongst crimes against humanity. This gives rise to serious legal difficulties. In addition to that, it runs the risk of creating a competition against historic tragedies, which should not be compared. And what is done, it's done to the detriment of the memory of victims. At the time when the United Nations is working on the development of a new international convention on the prevention and suppression of crimes against humanity, it seems to us important to recall that any and all resolution from the General Assembly has to be centered in international law and a universal approach to human rights. I thank you.
I thank the distinguished representative of France. We have had the last speaker in explanation of vote before the vote. The Assembly will now take a decision on draft resolution A/80/L48 entitled Declaration of the Trafficking of Enslaved Africans and Racialized chattel enslavement of Africans as a gravest crime against humanity. A recorded vote has been requested. We shall now begin the voting process. Those in favor of the draft resolution A/80/L48, please signify. Those against and those in abstention.
The Assembly is now voting on draft resolution A/80/L48 entitled Declaration of the Trafficking of Enslaved Africans and Racialized Chattel Enslavement of Africans as the gravest crime against humanity. Will all delegations confirm that their votes are accurately reflected on the screen? The voting has been completed. Please lock the machine.
The result of the vote is as follows. In favor, 123, against 3, abstentions 52. Therefore, draft resolution A/80/L48 is adopted. Before giving the floor for explanations of vote after the vote, may I remind delegations that they are strongly urged to limit explanations of vote to 5 minutes, which should in any case not exceed 10 minutes and be made from their seats. I give the floor to the distinguished representative of Trinidad and Tobago.
Thank you, Chair, Excellencies. I have the honor to deliver this statement on behalf of the 14 member states of the Caribbean Community, CARICOM, in explanation of our vote. CARICOM voted in support of this resolution because of our historical attachment to the issue of the trafficking of enslaved Africans and the racialized chattel enslavement of Africans. The recognition today by those member states that supported this resolution and the declaration is a critical first step towards redressing the injustices perpetuated over the 400 years of the transatlantic slave trade. In this vein, CARICOM remains a strong advocate for the advancement of reparatory justice for the historical atrocities perpetuated against our forebears during the period of colonialism and the transatlantic slave trade, as well as the persistent legacies thereof. CARICOM therefore reiterates our support in principle for this initiative undertaken by Ghana on behalf of the African Union to advance the issue of reparatory justice. Given the importance of this issue, CARICOM stresses that implementation of the resolution must be done in a collaborative manner and in full partnership with the entire membership. CARICOM commits to contributing to taking forward the implementation of this resolution in line with the region's priorities, including the 10-point plan for reparatory justice. We will continue to engage meaningfully in future discussions on this important issue, including on ways to take forward the important provisions contained in the resolution. I thank you, Chair.
I thank the distinguished representative of Trinidad and Tobago. I now give the floor to the distinguished representative of New Zealand.
Thank you, President. It is clear from the grim testimony that we have heard today that slavery and the transatlantic slave trade were appalling tragedies of an historic scale that constitute grave violations of human dignity and of the fundamental human rights of its victims. New Zealand recognises the profound and lasting impacts of the transatlantic slave trade and thanks Ghana for its efforts in bringing forward this resolution. We acknowledge the historical legacy of the transatlantic slave trade and its lasting impact on many member states, and we welcome the importance placed on continuing education and awareness raising and the increased attention that commemorative events have brought to the issue. New Zealand supports proposals for meaningful, truthful, and respectful dialogue among those most impacted, including reparatory justice and reconciliation through appropriate frameworks. We encourage the continued promotion of comprehensive educational programs, memorialization initiatives, and research on slavery, the trafficking of enslaved Africans, and racialized chattel enslavement of Africans and their consequences. We had hoped to be able to vote in favour of this resolution, but regrettably, New Zealand was not in a position to endorse all aspects of the text presented today. New Zealand acknowledges the significance and horrific scale of transatlantic slavery, but it is not able to endorse a text that suggests a hierarchy of crimes against humanity and which has implications for other multilateral processes underway related to the progressive development of international law. New Zealand acknowledges the importance of restorative justice processes, including issues such as reparations, but believes these are more appropriately pursued through relevant judicial tribunals or agreed international legal forums. New Zealand was, unfortunately, not able to vote in favour of the text today, but we thank Ghana and the other co-sponsors once again for the resolution and reaffirm our support for meaningful dialogue, education, and progress on addressing the impacts of the transatlantic slave trade. I thank you.
I thank the distinguished representative of New Zealand. I give the floor to the distinguished representative of Peru.
Gracias, Presidente.
Thank you, President. Peru would like to thank the distinguished delegation of Ghana for this initiative, which has made it possible for us to undertake a serious analysis about the seriousness of these issues. Our vote is consistent with the international commitments that Peru has undertaken in line with our struggle to eradicate racism and all of its structural manifestations. Peru voted in favor of the draft resolution. We are convinced that the transatlantic slave trade of Africans and the system of racialized slavery were violations of human rights of such scope that they demand the attention of the international community today. Their consequences are still being felt today in our societies. Our vote is also an act of recognition to the Afro-Peruvian communities. Some 200,000 Peruvians identify as such in our territory. This constitutes about 4% of our national population. But their political, economic, social, and cultural legacy goes beyond these figures, and it is part and parcel of our national identity. Peru has moved forward concrete policies in this domain, including the national policy for Peruvians of African descent going to 2030. But we'd like to make clear some interpretations of this resolution. First of all, we believe that the characterization of the transatlantic slave trade as the gravest crime against humanity contained in OP 2 and 3 is a reference to a particularly serious event in the past, which occurred at a specific time in history. We recognize that in line with international law, the commission of an illegal act is something that, if it continues, there have to be appropriate guarantees of repetition and redress adopted. But we note that OP 6 to 8 can be interpreted as a call for constructive dialogue. But this is not in prejudice to the establishment of obligations that could be interpreted as legally binding. The quest for justice should be something that is accessible, universal, and inclusive, free from all kinds of discrimination. The principles reaffirmed in this resolution should be a way of guiding states and should contribute to recognizing the dignity of human beings. Finally, we believe that, well, we would have preferred that a resolution on such an important issue should have been adopted by consensus. We reiterate our solidarity with all of those persons of African descent, and we particularly recognize the damaging legacy of slavery that persists today in a world where there is still racial discrimination as a result of this historical legacy. We will continue to work constructively in the context of this dialogue, and we hope that we can achieve this by consensus. Thank you.
I thank the distinguished representative of Peru. I give the floor to the distinguished representative of Liechtenstein on behalf of Switzerland and Iceland.
Thank you, Mr. President. I deliver this joint explanation of vote on behalf of Iceland, Liechtenstein, and Switzerland. At the outset, we underline the importance of the International Day of Remembrance of the Victims of Slavery and the Transatlantic Slave Trade, and commend efforts to ensure that the profound suffering caused by the trafficking of enslaved Africans is never forgotten nor diminished. To address the enduring consequences of slavery crimes, Liechtenstein launched the Finance Against Slavery and Trafficking Initiative to combat modern forms of slavery and human trafficking. Against this background, the process leading to the adoption of this declaration is unfortunately a missed opportunity to broaden consensus and recognize the unprecedented nature of these crimes. We believe that more time and meaningful negotiations were needed to galvanize further support. Although we stressed our intention to support the spirit of this initiative, we, alongside others, raised concerns about inconsistencies of the declaration with international law. In particular, the qualification of the transatlantic slave trade as the gravest crime against humanity has no basis in international law and risk undermining the Rome Statute protecting civilian populations not only against enslavement, but also against other equally atrocious crimes against humanity. This is all the more regrettable as discussions on the inclusion of slavery crimes in the definition of crimes against humanity are taking place at the moment, both as part of the efforts to draft a convention on the prevention and punishment of crimes against humanity, and also within the framework of the Rome Statute. These discussions are essential to guarantee that such atrocities are not repeated and that modern forms of slavery do not go unpunished. For these reasons, while we strongly support the underlying objective of recognition, we were unfortunately not in a position to vote in favor of the resolution as adopted. We remain committed to engaging constructively and support the remembrance of the trafficking, the transatlantic slave trade consistent with international law. I thank you.
I thank the distinguished representative of Liechtenstein on behalf of Switzerland and Iceland. I have the honor now to give the floor to the representative of the United Kingdom.
Thank you. The United Kingdom recognises the gravity of the issues addressed in this resolution and welcomes the opportunity to set out its position. We have repeatedly recognised the abhorrent nature of slavery and the transatlantic slave trade, which inflicted untold harm and misery on millions of people over many decades. Its horrors were profound, and its legacy continues to leave deep scars today. The UK also believes that only by acknowledging and discussing collectively the most painful elements of the history that we share with other nations, including the transatlantic slave trade, can we come together in a spirit of solidarity and mutual respect to respond to the challenges that we all face today. The UK remains committed to that goal. That is why we engaged constructively throughout the negotiations on this resolution in the hope of reaching a consensual-based text. However, despite our efforts, our concerns have not been taken on board. The UK continues to disagree with fundamental propositions of the text and therefore, regrettably, could not vote in favour of it. Firstly, the UK is firmly of the view that we must not create a hierarchy of historical atrocities. Doing so simplifies the complexity and vast scale of suffering endured in different contexts. It risks diminishing the experiences of communities whose trauma and suffering was felt just as strongly. No single set of atrocities should be regarded as more or less significant than another. We should approach all historical injustices with the same seriousness, empathy, and respect to ensure that no one group is made to feel that their suffering is being overshadowed or treated as secondary. Furthermore, it's essential and integral to the rule of law that the formation and evolution of international law is governed by clear and well-defined principles. The principles of intertemporality and non-retroactivity are long-standing tenets of international law. They are essential to ensuring legal stability. According to the intertemporal rule, the applicable law is the law of the relevant time. International courts and tribunals have routinely upheld these principles. There is equally no duty to provide reparation for historical acts that were not, at the time those acts were committed, violations of international law. These principles cannot be circumvented by recourse to the concept of continuing harms. The UK welcomes that states have developed international law such that today's slavery and the slave trade are rightly prohibited by treaties and under customary international law, and enslavement is now recognised as a constituent element of a crime against humanity. Nonetheless, it's important to acknowledge with deep regret that the prohibitions on slavery, the slave trade, and what are now considered crimes against humanity had not yet been established in international law at the time of the transatlantic slave trade. None of the recognized sources of international law, as set out in Article 38 of the Statute of the International Court of Justice, identify a prohibition on slavery and the slave trade until the 20th century. The United Kingdom appreciates that Ghana, on behalf of the African Union, consistently stressed that this resolution was not to be read as a legal document. This was restated by the drafters at every informal consultation. In this context, the UK and others offered specific language to move the text away from legal to political discourse, while still reflecting the sheer gravity and horror of the acts. Member States also suggested the text should be considered by the Sixth Committee. Again, this was met with the response that this was a political declaration. The United Kingdom is keen to underscore this point on the AU's intention, while we continue to regret the failure to accept language that would have put the matter beyond doubt. I thank you.
I thank the distinguished representative of the United Kingdom. I give the floor to the representative of the Kingdom of the Netherlands.
The Kingdom of the Netherlands remains firmly committed to addressing racism and discrimination. We share the importance that the African group attaches to the lasting consequences of slavery and the transatlantic slave trade. We fully recognize the profound injustice of this history and its continued impact today. In December 2022, the Prime Minister of the Kingdom of the Netherlands offered formal apologies for the actions of the Dutch state towards enslaved people in the past, who suffered as a consequence of those actions everywhere in the world, as well as to all their descendants up to the present day. In July 2023, His Majesty King Willem-Alexander apologized for the Netherlands' slavery past. As a member of the European Union, we engage constructively in the negotiations on this resolution, and we greatly appreciate the efforts by Ghana and the African Union to bring forward this important initiative. In this vein, I would like to also say that we align ourselves with the statement delivered by the EU, and we sincerely regret that no consensus could be reached on a formulation that addresses key legal and substantive concerns. Having said that, the Kingdom of the Netherlands cannot support references that suggest the retroactive application of international law, including the implication of a legal obligation to provide reparations for acts that were not a violation of international law at the time they were committed. We also cannot agree to the introduction of a hierarchy among crimes against humanity, including the designation of one as the gravest, nor to references related to the non-applicability of statutory limitations. For these reasons, Mr. Chair, and despite the importance we attach to this very subject matter, my delegation has abstained on this resolution. Thank you, Mr. Chair. Ik twijfel nu.
I thank the distinguished representative of the Netherlands. We have now had the last speaker in explanation of vote after the vote for this meeting. We shall hear the remaining speakers in explanations of vote after the vote at a later date to be announced. The Assembly has thus concluded this stage of its consideration of Agenda Item 119. Before adjourning the meeting, I will announce the results of the secret ballot. The Assembly will resume its consideration of sub-item 1 of Agenda Item 115, entitled Appointment of Members of the Board of the 10-Year Framework of Programs on Sustainable Consumption and Production Patterns. The result of the voting is as follows. Group A, African states, number of ballot papers, 180. Number of invalid ballots, 0. Number of valid ballots, 180. Abstentions, 7. Number of members present and voting, 173. Required majority, 87. Number of votes obtained by each member state, South Africa, 173. Group B, Asia Pacific states, number of ballot papers, 180. Number of invalid ballots, 0. Number of valid ballots, 180. Abstentions, 4. Number of members present and voting, 176. Required majority, 89. Number of votes obtained by each member state, India, 176. Group C, Eastern European states, number of ballot papers, 180. Number of invalid ballots, 0. Number of valid ballots, 180. Abstentions, 7. Number of members present and voting, 173. Required majority, 87. Number of votes obtained by each member state. Hungary, 158. Russian Federation, 126. Group D, Latin American and Caribbean states. Number of ballot papers, 180. Number of invalid ballots, 0. Number of valid ballots, 180. Abstentions, 6. Number of members present and voting, 174. Required majority, 88. Number of votes obtained by each member state. Barbados, 173. Mexico, 168. Group E, Western European and other states. Number of ballot papers, 180. Number of invalid ballots, 0. Number of valid ballots, 180. Abstentions, 11. Number of members present and voting, 169. Required majority, 85. Number of votes obtained by each member state. Finland, 168. Germany, 166. The following states have thus been appointed as members of the board of the 10-year framework of programs on sustainable consumption and production patterns for a term beginning on 25 March 2026 and ending on 24 March 2028. Barbados, Finland, Germany, Hungary, India, Mexico, the Russian Federation, and the Republic of South Africa. I thank the tellers for their assistance. Members are reminded that the following vacancies remain to be filled for a term beginning on the date of the appointment and expiring on 24 March 2028. 1 member from among the African states and 1 member from the Asia Pacific states. The Assembly has thus concluded this stage of its consideration of sub-item 1 of Agenda Item 115. I thank the interpreters for the extension granted. The meeting is therefore adjourned.